Does the Genocide Convention still hold relevance in our current global landscape? Let's trace its roots back to 1948, when the world was grappling with the aftermath of World War II. The Convention on the Prevention and Punishment of the Crime of Genocide, or as we know it, the Genocide Convention, was born out of necessity. It was the first human rights treaty adopted by the United Nations General Assembly, a significant milestone in international law. The convention was groundbreaking in more than just its timing. It was the first to codify genocide as a crime, defining it as acts committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. This definition expanded the scope of punishable crimes, recognizing genocide as a crime that can occur both in times of war and peace. The convention placed an obligation on its 153 state parties, including India, to not only refrain from committing genocide but also to take all necessary measures to prevent and punish such heinous acts. However, it's important to note that not all states, including India, have enacted legislation on this subject. The International Court of Justice, the principal judicial organ of the United Nations, hears cases related to the interpretation and application of the convention. The court's role in settling legal disputes and providing advisory opinions is crucial in upholding the principles of the convention. Despite its age, the convention remains a crucial tool in preventing and punishing acts of genocide. Now, how does this convention come into play in today's world? Let's look at the recent ICJ case, South Africa versus Israel. South Africa, in a rare move, brought a case against Israel at the International Court of Justice. The crux of their argument was that Israel's military operations in Gaza constituted a violation of the Genocide Convention. They contended that the actions and tactics employed by Israel were not just acts of war, but acts committed with the intent to destroy, in whole or in part, the Palestinian group, an act that falls squarely within the definition of genocide. The International Court of Justice, in its interim ruling, determined that Israel must take measures to prevent acts of genocide against Palestinians in Gaza. However, the court did not order a ceasefire and did not find Israel guilty of genocide. This ruling, though not a final judgment, may increase international pressure on Israel to address the conflict. Now let's delve a little deeper. One voice in the court offered a differing perspective. Ugandan judge Julia Sebutindi, the first African woman on the ICJ, voted against all emergency measures requested by South Africa against Israel. She argued that the Israel-Palestine conflict is political, not a legal matter, and that South Africa failed to demonstrate genocidal intent on the part of Israel. This dissenting opinion sparked controversy and differing opinions among experts and officials, further highlighting the complexities of applying the Genocide Convention in real-world scenarios. While the final judgment is yet to be made, this case undeniably underscores the ongoing relevance of the Genocide Convention. So, with this case in mind, where does the Genocide Convention stand in today's world? The Genocide Convention, officially known as the Convention on the Prevention and Punishment of the Crime of Genocide, 1948, continues to play a pivotal role in shaping international relations and human rights law. It stands as a beacon reminding us that the deliberate and systematic extermination of a racial, ethnic, religious, or national group is an unspeakable crime against humanity. This convention, the first human rights treaty adopted by the United Nations General Assembly, was a significant step in codifying the crime of genocide. It defined genocide as acts committed with the intent to destroy in whole or in part a national, ethnic, racial, or religious group. This definition is as relevant today as it was over 75 years ago, as it continues to guide the international community in identifying and addressing acts of genocide. The Genocide Convention, ratified by 153 states, holds each state responsible for preventing and punishing the crime of genocide. It mandates that states enact legislation to this effect and hold perpetrators accountable. This responsibility, while not universally upheld, serves as a powerful reminder of the collective commitment to prevent such heinous acts. The convention's influence extends beyond its signatories. Its definition of genocide has been adopted at both national and international levels. The Rome Statute of the International Criminal Court, ICC, for instance, has incorporated the convention's definition of genocide in its Article 6. This broad acceptance of the convention's definition underscores its ongoing significance and influence. Moreover, the International Court of Justice, ICJ, the principal judicial organ of the United Nations, hears cases related to the interpretation and application of the Genocide Convention. This places the convention at the heart of international law and dispute resolution, ensuring its continued relevance and applicability. In a world where conflicts are far from extinct, the Genocide Convention continues to serve as an indispensable instrument in promoting and preserving human rights and preventing atrocities.